Good afternoon. My name is Matthew Parker. I'm an attorney with the firm of Marshall, Parker & Weber. I want to welcome you to the Elder Law Update webinar. Uh, each year I have the honor of presenting my material with regard to elder law and estate planning issues at Marshall, Parker & Weber's Professional Update, typically held here in Williamsport as well as in Wilkes-Barre. For this webinar, I'm going to give you an abbreviated version of my materials from the 2016 event. So if you were unable to attend, this will give you an insight as to some of the hot topics that came up last year and might come up in the near future. And I should point out that if you want to ask a question, there's a Q&A section on your screen where you can actually ask a question. Hold on.
Attendees are in listen-only mode.
Of the topics that over the last year and might come up in the near future. So, and everybody listening to the webinar, if you haven't listened to one of these before, should understand that you can ask questions, and hopefully by the end of the session I'll be able to get to some of your questions, so you can check that box out on your screen and enter a question about some of the materials or something else perhaps that I haven't covered. Well, the biggest topic was the movement of our long-term care Medicaid program to a managed care system. Last year, the governor directed the Departments of Human Services and Aging to develop a plan to shift Pennsylvania's administration of Medicaid long-term care services to a managed care model. This means that Pennsylvania is soon going to be hiring private insurance companies, referred to as managed care organizations or MCOs, to administer our state's Medicaid-funded long-term care services. The program is going to be called the Community Health Choices Program, and the population covered will include adults who are age 21 years of age and older who require Medicaid long-term care services, whether that's in the community or in private or county nursing facilities, and those who are dually eligible, those who qualify for both Medicare and Medicaid, who are 21 years of age or older. Now, these dual eligible individuals do not need to be receiving long-term care services. Now, persons in the Community Health Choices population will be required to enroll in the program. However, those individuals who are eligible for the LIFE program will not have to be enrolled in the program unless they specifically ask to be enrolled. The population will also not include Act 150 program participants, individuals who are receiving their services through the lottery-funded options program, or residents of state-operated nursing facilities, including the state veterans homes. Now, these managed care organizations will be accountable for most Medicaid-covered services, and that includes preventative services, primary and acute care, home and community-based services, long-term care services in nursing facilities, prescription drugs, and dental services. Now, those Medicaid recipients already enrolled in a managed care organization, such as those dual eligible participants, will be entitled to have their services coordinated by the same MCO. With regard to the various long-term care living waiver programs, there will be one waiver program to offer all the various services currently covered by our state's waiver programs. It's going to be known as the Community Health Choices Waiver. The only waiver that will survive after this merger of the waiver programs will be the OBRA waiver, which will continue to operate for those who do not qualify for this new CHC waiver program. Now, there's going to be a 6-month rollout period for the services to be provided by the MCO. The current enrollees can keep their providers for 180 days or until the new service plan is implemented. Following the implementation of the new plan, new enrollees or those that are transferring between MCOs are going to have a 60-day continuity of care period. For those of you who are providers, your services can be provided by the MCO for 6 months after the plan is rolled out. After that 6-month period, the MCO is supposed to have a provider network that not only meets the needs of their participants, but also allows for participant choices between providers. Now, be aware that the managed care organization is not prohibited from having an affiliated service provider. They are supposed to ensure that their participants have adequate providers in their network so they can have access to care. So there shouldn't, for example, be one home health care agency in a network. However, it's going to be interesting to see if the managed care organizations are going to allow for fair competition in their network when it ultimately could affect their bottom line. Now, one part of the managed care plan that's already been rolled out is the processing of applicants for home and community-based services through an enrollment broker called Maximus. Any individual who's seeking to enroll in one of the long-term care living waiver programs will be able to acquire the level of care determination via a referral to Maximus, or the referral can go directly through the Area Agency on Aging. Now, once the level of care assessment is completed by the Area Agency on Aging, Maximus will then visit the applicant to determine the programs that meet the applicant's needs. Once the needs are determined, the Medicaid application is supposed to be filed with Maximus and then forwarded to the County Assistance Office, who then determines financial eligibility. Now, the timeline for implementation of the managed care plan is rather extensive. In fact, it was just postponed by the administration for 6 months. At any rate, this year, the managed care organizations are supposed to be selected. From 2017 through 2019, various regions of the state will slowly be phased into the managed care organizations. We, here in Williamsport, are in the Northeast region, and we are scheduled to be phased in during 2019. Now, there is a new federal law that will require hospitals to notify patients of their status as outpatients and that they haven't actually been admitted to the hospital. And consequently, they're also supposed to be notified of what that means in terms of the various cost-sharing requirements under the Medicare program. Now, this law is known as the Notice Act, and it was signed by President Obama on August 6th of last year. And as I explained in my materials last year, outpatient status as a person in a hospital limits the individual's ability to receive Medicare coverage under Part A for skilled care in a nursing facility after a person's been discharged from the hospital. Now, the new law aims to eliminate a lot of the confusion and the surprise out-of-pocket costs for Medicare beneficiaries who simply don't realize that spending a night or two in the hospital doesn't make somebody an inpatient. Now, the law is going to apply in situations where a patient is receiving services as an outpatient for more than 24 hours. It's going to require hospitals to notify those patients of their outpatient status within 36 hours or upon the discharge, whichever occurs sooner. And this law is supposed to become effective in August of this year. The outpatient notification will have to explain that the beneficiary will be subject to the cost-sharing requirements that apply to outpatient services under Medicare Part B, and that the beneficiary's outpatient status will not count towards the 3-day inpatient stay required under Medicare Part A for that subsequent skilled nursing facility coverage. The notice is also supposed to be signed by the individual or a representative acting on the individual's behalf. Now, in 2014, Pennsylvania enacted a state law which requires hospitals to provide a very similar notice of observation status. Pennsylvania's notice is directed to outpatients who receive on-site services for more than 23 consecutive hours. And the state law covers a stay in a hospital bed where meals have been provided in an area of the hospital other than the emergency room. Therefore, Pennsylvania's hospitals will likely need to provide notices that comply with the slightly different requirements of both the Pennsylvania and the new Federal Notice Act. Now, there's a new law that will end two techniques that married couples use to maximize their Social Security benefits. One is called the file and suspend technique, and the second is called filing for a restricted claim of spousal benefits. Those claiming techniques made it possible for many couples to obtain spousal Social Security benefits while continuing to accrue what are called delayed retirement credits. So here's how the file and suspend technique was used. Your spouse cannot claim a spousal benefit based upon your work record under Social Security unless you've already applied for your own Social Security benefits. But Social Security rules permit workers who reach their full retirement age to apply for and then put off, that is, suspend receiving your benefit for up to 4 years to a maximum age of 70. So by filing for Social Security, you would allow your spouse to receive his or her spousal benefits based upon your earning record, but then you'd go and suspend your own Social Security. You get to increase your eventual payouts at the rate of 8% per year. So this file and suspend technique is now eliminated by the 2015 Budget Act. You actually now have to be receiving Social Security payments for those spousal benefits to be available. Now, a person can still suspend their benefits and get those delayed retirement credits, but the spousal benefits will not be paid during the suspension period. The elimination of the file and suspend technique took effect on April 30th of this year. Those persons who request for the benefit suspension were submitted prior to that time will not be affected. And the filing of the restricted claim for spousal benefits is very similar to file and suspend. Until now, someone reaching full retirement age could basically file a restricted application and request only those spousal benefits. Of course, this allowed the worker to receive Social Security payments while continuing to earn those delayed credits on their own record. At 70, they could just switch to the enhanced payments. Well, the Act does away with this strategy by presuming that when you file an application for spousal benefits, it's also an application for the benefits on the worker's record. And the elimination of this restricted claim strategy applies to anybody who attains age 62 after the 2015 calendar year. Now, last year I reported on the ABLE Act. Section 529A of the Internal Revenue Code authorizes a new form of tax-free savings accounts for individuals who became severely disabled before they reached the age of 26. Earnings on an ABLE account will not be subject to federal income tax, and perhaps more importantly, the funds in the account will not disqualify the owner from continued benefits under the Supplemental Security Income Program and the Medicaid program. So money in these accounts can be saved for future expenses and needs without jeopardizing the owner's SSI and Medicaid eligibility. Now the Internal Revenue Service has released some proposed regulations implementing this new act. The regulations will give guidance to states who want to establish these programs. Now it's going to take some time for the IRS to get these regulations approved. In the meantime, Pennsylvania has issued its own regulations, but out of State Senate Bill 879, the accounts in Pennsylvania are going to operate very similar to the 529 college savings plans. Now, a few of the highlights for Pennsylvania's regs include a termination provision, where the Treasury Department can terminate an account if it's in the best interest of the individual. There's an administrative appeals process if the individual disagrees with the termination. The accounts also have a spendthrift protection. They cannot be subject to attachment, levy, or execution by a creditor of either a contributor to the account owner, or the designated beneficiary. And perhaps most surprisingly, the proceeds in the account are not subject to what's called a payback requirement to the Department of Human Services for any Medicaid benefits received by the beneficiary. Now that provision is really in contrast with the law passed by Congress, so that may make the creation of these accounts in Pennsylvania really attractive to individuals across the country. Now, the Supreme Court of Pennsylvania updated rules of procedure related to a practice in what's called the Orphans Court. This is part of what the local Court of Common Pleas deals with matters relating to estates of the deceased or maybe incapacitated persons as well as minors. This part of the court has had rules that varied greatly from county to county. So the procedure in, for example, Tioga County would differ greatly from what goes on here in Lycoming County. Many of the Supreme Court's orphan court rules have now been revised, and they're binding on all these local courts across our state. Any local rules conflicting with these new rules are going to be vacated by September 1st of this year. Some of the highlights of the rule changes: there's a requirement that all attorneys now use the Supreme Court forms when practicing in these orphans courts. There are now uniform rules related to what's called accountings, typically used in the state. Standardized practice will now exist for preparing the account, filing the account, the notice to all the interested parties, the manner and nature of raising the objections, and the adjudication of the account. In addition, petition practice, that is the requesting of relief to the court, is now going to mirror that of the civil side of the court. So hopefully the changes will make the practice in orphans court a lot easier for lawyers and judges alike. Pennsylvania has proposed a change to its power of attorney law. This change follows the substantial overhaul of the power of attorney law last year that introduced new notice and acknowledgement provisions and the requirement that so-called estate planning hot powers had to be explicitly authorized in new powers of attorney. Now, the proposed change once again targets the notice and acknowledgement of the power of attorney. These pages, of course, are on the front and back of our financial powers of attorney. They serve to give notice to the principal that they're giving up a lot of power to the agent, and also the agent has to acknowledge that they're going to use the power of attorney in the principal's best interest. In Pennsylvania's House Bill 299, it's proposed that the content of the notice now include a provision that if the principal believes the agent is not acting properly and believes that they're a victim of financial abuse, they can call the Department of Aging's Elder Abuse Hotline, and the hotline phone number has to be included in the notice page. In addition, the acknowledgement page would now include a provision that the agent acknowledges that any intentional act or admission on the agent's part may subject the agent to criminal penalties. Now, elder abuse is a major issue facing our state and nation. It's estimated that 1 in 5 seniors over 65 have been the victim of financial abuse, with the costs in the billions of dollars. So this proposed addition in our power of attorney forms is intended to help older adults have access to help if they believe they're the victim of abuse. Some attorneys believe the revision goes a little too far, and some of the agents may be unwilling to serve in light of the really strong language recommended for the document. But the legislation's in committee, and it does have some bipartisan support. A new Pennsylvania law gives lay caregivers a bigger role in the planning to transition their loved one back home after they've been discharged from a hospital. The recently passed CARE Act gives the patients the opportunity to appoint a lay caregiver prior to hospital discharge. And the goal is to ensure that caregivers will have some key information related to the patient's discharge and any aftercare assistance program. Now, the full title of the law is the Caregiver Advise, Record, and Enable Act. The law is aimed at helping our seniors get home with the proper care plan and prevent unnecessary readmissions to the hospital. The law provides that upon admission to a hospital and prior to discharge to a residence, a patient will have the chance to name a lay caregiver. Now, the definition of admission to a hospital is limited to an inpatient. Now, a patient is not required to name a lay caregiver. They will simply have the opportunity to do so. Now, interestingly, the law does not mention the role of an agent under a power of attorney for someone who's incapacitated. It only provides that a legal guardian, someone appointed by the court, can name a lay caregiver for someone who's incapacitated. The Act does say that a lay caregiver could be named in another document, such as an advance directive. Now, the lay caregiver will have access to medical records under the HIPAA law, but only with the consent of the patient or the legal guardian. The hospital is required to notify the lay caregiver of any discharge from the hospital or a transfer to another facility. The hospital will then meet with the caregiver and discuss the contents of the discharge plan and any aftercare assistance and instructions for providing that care. The law is supposed to take effect 12 months after signing by the governor in this past March. Supporters of the law believe that by building these relationships with the caregivers during the patient's stay in the hospital, the care team can better prepare caregivers to understand and then follow care plans when patients go home or to other settings. There have always been exemptions from jury duty for some people. For example, those in the armed services, persons who would face undue hardship, such as someone who's pregnant, they can be excused. Now, until recently, seniors were not automatically excused from jury duty. Now, thanks to a new PA law, any person over the age of 75 is not required to serve on a jury. Now, they'll still be called for a jury duty, but they can then ask to be excused based upon their age. They don't need to be disabled. Their age of 75 is the only criteria. For some of my clients, traveling to the court and participating in the whole jury process is just quite stressful. So thankfully, they can now avoid the requirement to serve on a jury. Now, Pennsylvania Appellate Court ruled in the case of Iori versus Iori that you can be ordered to help pay for your parent's caregivers if your parent doesn't have enough money to pay them. And the court went on to also rule that your obligation to pay for your parent's care doesn't turn on whether or not you had a good or a bad relationship with your parent. And your obligation to your parent comes before some of your other personal expenses, such as in this case, your stepchild's college education. Now, Pennsylvania's filial support law allows an indigent person, that is someone who can't pay their bills, to sue a child to help pay for the parent's support. In the Iori case, Mrs. Iori was a 90-year-old woman who required 24-hour care to live at home. Her rather modest Social Security was insufficient to pay for the care. In this case, Mrs. Iori's agent sued two of her kids on her behalf to force them to help pay for her caregivers. Her son, Russell, claimed he didn't have a very good relationship with his mother, and he had other financial obligations, including paying for his stepchild's college education. The Superior Court of Pennsylvania affirmed the lower court's decision and ordered Russell to pay for some of his mother's care. The court found that the existence of a bad relationship with the parent was not a defense to a filial support claim, and the financial obligations to support a stepchild, such as college expenses, were found to be insufficient evidence of the inability to contribute something towards the cost of his mother's care. Russell was ordered to pay $400 per month towards her care. Well, we all know that a lot of families have strong bonds and they care for their aging parents. However, other families are simply fractured and they have no interest in helping each other. In Pennsylvania, that lack of a relationship with your parent doesn't have any bearing on your financial obligation to help your parent under this filial support law. I found it rather surprising that the cost of keeping an elderly parent at home by paying private caregivers takes precedence over the obligation to educate a stepchild. The court in this case focuses on the lack of a blood relationship to discredit the college expenses as legitimate. Given the holding in this case, however, it's not going to matter if this is a Brady Bunch family and Mike Brady, for example, is paying for Marsha Brady's Penn State tuition. In accordance with this holding, his estranged mother, 24-hour care is going to take precedent over Marsha Brady's education. It's an interesting and somewhat troubling case for all of us. Well, that's going to do it for this year's Elder Law Update. I want to thank you all for attending. I just want to give you notification of two events that are coming up. We have a webinar on July 13th called Caregiving from a Distance, and I'm involved with that with my care manager and coworker Karen Griswold. We're going to talk about how to make visits with your loved one productive if you're a caregiver, how do you share duties with family members, getting help from a care manager, and the benefits of documents like powers of attorney. And then on August 17th, we have Retirement Income Strategies with attorney Nick Lutz and Nancy Burns, a home retirement specialist. And they're going to talk about drawing on retirement accounts like IRAs, Social Security claiming strategies, always a big topic, as well as reverse mortgages. So July 13th and August 17th, both of those at 1 o'clock if you can tune in. That will do it for today. Thank you so much for attending.